We don't have a ton of time to go through everything, so I'm just going to try and hit some highlights of some different things that you should be considering, or maybe some of your relatives should be considering regarding your estate planning. So we'll start out with late adolescence, which is really, I think you're a college student or you're 20-somethings who maybe don't have a lot of assets yet. So they're thinking, I don't have anything to give away, I don't need a will, so I don't need an estate plan. But as you might remember, if you've been to one of the last 23 seminars, estate planning is more than just writing a will. So as Alyson and Dick have both touched on, incapacity planning is really important for all ages. You usually think of planning for incapacity with a power of attorney and a living will to be something to think about maybe later in life when you have some kind of chronic illness or you're getting Alzheimer's, you think of something later in life. But they can also help plan for temporary incapacity. So say your son goes off to college and he breaks his leg in a pickup basketball game and they have to take him into surgery. Once he gets out of surgery, he'll be fine and he can start taking over his affairs again. But who is going to make the healthcare decisions when he's under anesthesia, but he's adult? So who's going to do it if he doesn't name someone? So Alyson briefly went through what these documents are, but there are three main documents that we prepare. Power of attorney is the first one, which is when you name the person or persons that you would like to help with your financial affairs if you become incapable, or even if you're not. The living will is usually combined with the appointment of a healthcare representative in Connecticut. So the living will is if you're terminally ill or permanently unconscious, what are your wishes with regard to life support, food and IV, hydration? What do you want or what do you not want at that point in time? But maybe more importantly is the appointment of the person who's going to carry out those wishes. So you can appoint a healthcare representative for both end-of-life decisions when you are terminally ill or permanently unconscious, but also, like we talked about, for more everyday decisions, you can name a healthcare representative for sort of that temporary incapacity and the non-end-of-life decisions. And the third one is the designation of conservator, which Alyson talked about, which is basically the document that says, if I'm going to be conserved, here is who I would like to serve as my conservator. So the point here is just that incapacity documents are important starting young and all the way for the rest of your life, so basically through all of the stages. The next stage that I'll talk about is early adulthood. So think, you're starting to get married, maybe you're buying your first house, you're starting to have children. You might not have a lot in the way of assets still, so you might still be thinking, do I really need a will? If I don't have a lot of stuff to give away, why do I need a will? A will can do a lot of things besides just giving your stuff away when you pass away. It can plan for a lot of contingencies. So for instance, if you and your spouse pass away at the same time, or if your spouse passes away before you do, who do you want to have your stuff or to be your executor or to take care of your affairs in that situation? Or maybe you have a family heirloom, some jewelry that got passed down to you, that you really want to go to a specific person and you don't want, as Dick mentioned, sort of the default rules to apply to your estate. You might want to put that down in a will, exactly who you want specific items to go to. As soon as you have children, there are really important reasons that you might need a will or that you should have a will. You can name guardians for the minor children. So if both spouses or both parents pass away, who's going to take care of your small children? And similarly, if both parents are not alive anymore, but there's a lot of money, say there's life insurance, there might be a house or the house just got sold, who's going to manage the money for the children before they become adults and can manage money for themselves? And do you want them to have the money at 18? Do you want them to have it at 21 or 73? Or some people, the longer you go, the higher the age is for that. But so there are a lot of things besides just giving your stuff away at death that a will can help provide for. The other thing, Dick mentioned beneficiary designations. So there are things like life insurance, retirement accounts, payable on death accounts, that as long as you name a beneficiary, that passes outside your will. And it's something that you really need to make sure is updated periodically to make sure it's still going to the people that you want to have it. Also, just thinking about getting life insurance in the first place, or maybe getting more life insurance at this stage. My husband and I, for instance, just bought a house in Southbury, and we have a large mortgage that neither one of us could take care of by ourselves based on our salaries. So we're looking into more life insurance. So hopefully nothing ever happens and we never need it. But it's a lot easier to get life insurance now while we're young and healthy than it is later. And it's a just-in-case policy. So it's something else to be thinking about at this stage. The next stage, I put these arbitrarily in midlife only because it seemed like a good place to talk about them. Alyson mentioned a lot of the issues related to divorce and blended families, but I thought I should touch on it again. As she mentioned, if I name my husband as my executor in my will, he gets all of my stuff when I pass away. He's named as my power of attorney, he's my healthcare he's my guy for everything. But say at some point we get divorced, and at that point, the statute, so the law, automatically revokes all those appointments of my now ex-spouse, and it revokes the gifts or the bequests that went to him. So it doesn't revoke my will altogether. My will's still valid, or my power of attorney is still valid, but anything related to my spouse essentially is revoked, which could be a good thing. Maybe that's what you want. As Alyson said, maybe you don't want your ex-spouse to have anything to do with your stuff. But what if it's not what you want? Maybe you still want to take care of them, because they're taking care of your children. It's just something that you need to revisit at that point. And I should also point out that not everything is automatically revoked. So in Connecticut, things like beneficiary designations that are like life insurance, retirement accounts, those are not automatically revoked. So if I get a $500,000 life insurance policy and I name my now husband as the beneficiary, we get divorced and I don't do anything, he's gonna get $500,000 when I die because I never changed anything. And again, maybe that's what I want and I don't need to make any changes, but it's something that you need to be aware of. If you move out of the state, which Jim is gonna talk about that, different states have different rules. So some states might automatically revoke everything, including life insurance beneficiary designations. Some states might revoke none of it, so you really need to pay attention to your wills. So it's just something to be aware of if these changes happen in your life. Some issues related to blended families. So a lot of people think of sort of the simple will, right? Would be, I give everything to my spouse, and if my spouse passes away before I do, everything goes to my kids. Which a lot of times is all you really need in sort of the perfect family that Alyson mentioned. 2 parents, 2 kids from the same parents. But as soon as you blend families together, so each spouse brings different children to the marriage, there could be problems with that. So if I get married for a second time, we each bring children to the marriage, and then I pass away and everything goes outright to my second spouse now. He can turn around and change his will and get everything to his kids, and my kids don't get anything. So most people, as Alyson said, don't foresee this conflict, don't think anything like this would happen, but you don't know what situation is going to happen down the road. Maybe your spouse gets remarried later. You don't really know who's going to be involved. So one way to handle that is if I, instead of giving everything just outright to my second spouse, if I put everything in a trust, where maybe my spouse can get the income off of that trust, I give them the right to withdraw a certain amount from the trust every year, so my spouse is still taken care of. They can get whatever it is they need. But if my spouse passes away, when my spouse passes away, then that money can partly go back to my children. I can still control where that money ultimately goes, but still make sure that my spouse is taken care of. So that's one of the ways around that issue. Another issue, or just similar to the divorce issue, is if I get divorced, the designations related to my spouse would be revoked. it doesn't automatically revoke. Like if I gave something to his kids and then I get divorced, that part doesn't get revoked automatically. So it's something that you just need to revisit if something major changes. Finally, I lumped together sort of mature and late adulthood, which is sort of the typical estate planning that you're thinking about. One of the things that comes up at this point is planning for multiple generations. So maybe you have grandchildren or great-grandchildren, and you're trying to figure out how to help take care of them as well. Maybe your kids don't need it as much. One thing to consider, although Dick talked about how the estate and gift tax exemptions are going up and up and up, but they might go down again. No one really knows. If you're worried about gift and estate taxes, there's an annual gift exclusion of $15,000 per year per person. So you could give $15,000 to each of your grandchildren per year without incurring any taxes or using up any of that exemption. So it was definitely something that was of more concern several years ago when exemptions were lower, but it's something to think about. Keep in mind, though, that if you're worried about long-term care and Medicaid planning, that exemption does not apply to the 5-year look-back period. So you could get in trouble if you have to weigh what your concerns are and what the best way to handle all of these competing issues are. Another thing is just thinking about trusts for your grandchildren, to see if they're 2 years old right now, you might want to provide for them later, but you don't want them to have the money when they're 5. So you want to set up, trusts for them to make sure they're taken care of responsibly. Another thing, like I said, that sometimes is sort of competing interest is just tax planning and long-term care planning. So Alyson is an elder law attorney, and one of the things she specializes in is long-term care planning. She also has her LLM in tax, so really she just does everything. So either of these things, just go to Alyson. But that's one of those things that at this point in time is really starting to get important as you're thinking about what your legacy is going to be. The other thing, Dick actually talked a lot about this, so I will just touch on it, is considering whether a revocable trust is something that you're going to want or need. So it can help not avoid probate, because you're going to need to file something in Connecticut for probate, but it can simplify probate. It can also help ease some incapacity planning. If you name maybe a child or a spouse as a co-trustee, it can be a smoother transition for taking care of your property. Also, if you have continuing trusts, so if you want to set up continuing trusts for your children or your grandchildren, if you create those trusts under your will, the probate court is going to continue to have jurisdiction over those trusts until they end. So there are certain accounting requirements, sort of like the conservatorships, where you might have to file periodic accountings, you're going to have to file a final account. So there could be additional fees and hassle associated with that. Where if you set up trusts under a revocable trust, that's not automatically subject to probate court supervision. Although, as Dick said, revocable trusts aren't right for everyone. Sometimes the mix of assets you have makes it not ideal. Sometimes just the upfront hassle of retitling things isn't worth it compared to the benefits you get when you pass away. So it's just something to keep in the back of your mind, but you're really going to have to go sort of on a fact-specific basis whether revocable trusts are really going to do what you want them to do. So that's a lot to throw at you in a short amount of time, so I figured I would give you some overarching general rules that hopefully you will remember if you forget everything else. Although Dick gave you 2 things that you already have to remember, so I feel like the list is growing, but you'll get it. So general rules. We generally recommend that you revisit your estate planning at least once every 5 years, just because that's a good amount of time to just make sure that changes in your life don't require changes in your estate plan. But there are a lot of different changes where you might want to revisit sooner than that. So there might be changes in your own life. Maybe you're aging, maybe your assets have changed. You just came into a big inheritance. Maybe you're worried about incapacity sooner rather than later. There are a lot of things maybe you're retiring and you just don't know what to do with yourself and you're trying to figure out how you're going to manage your estate plan. All of those things are good reasons to just revisit. In your family's lives, maybe one of your grandchildren has special needs now, so you want to see how you can definitely make sure to provide for that grandchild and maybe rebalance things a little bit. Or maybe one of your children has some substance abuse issues and you're worried about creditor protection and maybe protecting them from themselves. So you might want to reconsider based on your current circumstances. There could be changes in the lives of your fiduciaries. So the fiduciary is the person who's going to take care of everything, including the executor, the agent under your power of attorney, your healthcare representative. Those people are all fiduciaries. So they could have passed away, or maybe they're having their own health issues and they can't take care of their own affairs, let alone yours. Or maybe the relationships change. Like Alyson said, if you don't review things in 20 years, who knows what your relationship with, the people that you named now are. I finally got my own parents to revisit their estate plan after probably 30 years. My youngest brother wasn't even named in them because he wasn't born yet, so that's the last time they updated their documents. But I didn't really think they needed to update things as far as their will goes. That pretty much was the same, everything to the spouse, everything to the kids after that. But it was really their incapacity documents, like their power of attorney and their healthcare representative, where they named siblings that they hadn't talked to in 5 or 10 years. So I was trying to tell them, those are the things that I'm really worried about. Make sure that the person who's named in those situations are people who know you and know what your wishes are and really are clear on what their job is. So that's another really good reason to just make sure you revisit every 5 years or so, just to make sure that everything is still up to date. And then of course, every once in a while, there are changes in the law. So there was major tax law changes a year or two ago, as you may or may not have noticed. We, as a firm, really try to get the information out there when things like that change, but also it's a good idea to just stay on, keep tabs on it yourself and come see us if you think any of the changes are going to affect you. So that's all I have. If you have any questions or anything, any one of us would be happy to. I think we'll maybe do a Q&A depending on time at the end, or most of us will stick around afterward to answer any questions. So I get to introduce Jim now. He is newish to our firm as of about a year ago, along with Dick. Several attorneys came over and we merged. He basically holds down the fort at our Southbury office. And now that I live there, I try to visit him a lot more. He has been a great addition to the department. Besides his sense of humor, he brings a lot of knowledge about tax and business law issues and some more complicated estate planning. He also has an LLM in tax, so we're cornering the market on that, I guess. And he's also the snappiest dresser, I think, in the department. So that's the other thing. So with that, I will let Jim talk about one other type of change and what you should consider.